You're stopped at a red light, waiting for the green light, and then all of a sudden, you get plowed from behind by a driver sending a text message. Or you're at Publix or Winn-Dixie picking out some peppers when you take a step and all of a sudden your foot goes out from under you because of some liquid on the ground, causing you to fall hard on your knee and twist your back. You've been injured in Florida and you reach out for help. You hire a lawyer and suddenly you hear terms like treating doctor, demand package, discovery, depositions, mediation, trial. So, what actually happens in a Florida personal injury case? Let's walk through the process, step by step, from the injury itself all the way through the possible trial. Now, the process usually starts immediately after the incident. In both automobile and slip and fall cases, what we call premises liability cases, the first priority is your health, medical treatment, and preserving evidence. For car crash cases, that may include crash reports, vehicle photos, witnesses, dash cam videos, electronic data recorders or black box recordings, and gathering insurance information. For the premises liability cases, it may involve incident reports, surveillance footage if possible, photos of the dangerous condition that caused the injury, identifying who controls the property. But the medical side is where most cases really begin. Now, one of the biggest misconceptions people have is that injury cases move quickly. They usually don't, because before a case can truly be evaluated, the injured person often needs time to treat and recover. Now, that process depends on the type of injury, how serious it is, how the person's body responds to treatment, whether the condition improves, stabilizes, or becomes permanent. Listen, some people recover in weeks. Others may require physical therapy, pain management, MRIs, orthopedic care, neurological treatment, and even surgery. Every person heals differently. Two people can have the exact same crash and completely different recoveries. So this stage is critical because the medical treatment helps establish the diagnosis, the causation, the extent of the injury, future medical needs, and whether the injury is permanent in an automobile case. Now, while treatment is ongoing, or sometimes after treatment stabilizes, the case enters what we call the pre-suit phase. This is where the lawyer gathers medical records, bills, evidence, wage loss documentation, family statements, liability evidence. In car crash cases, this may involve PIP claims, bodily injury claims, uninsured motorist claims. In the premises liability claims, they're usually pursued against businesses, property owners, and their insurance carriers. Now, once enough information is gathered, a demand package is sent to the insurance company. If the insurance company denies the claim, disputes liability, or refuses to offer a fair value for your compensation, the next step may be litigation. That starts with filing a lawsuit called a complaint. And the complaint basically says what happened, why the defendant is legally responsible, and what the damages are that are being complained of. Once the defendant is formally served, they file a response within 20 days. That's called an answer. Now, this leads into discovery, the formal exchange of information between the parties. This is where both sides can use the legal system to investigate the case. Discovery happens in both car crash and premises liability cases. The phase may include interrogatories, which are written questions that have to be answered under oath by the parties. Requests for production. Basically production of documents, medical records, photos, videos, maintenance records, employment records, surveillance footage. Requests for admission. Essentially, what we're requesting is the other side to admit or deny specific facts or even evidence or documents. This stage can feel invasive to clients, but much of this information is legally discoverable, meaning the other side can ask and get that information because of the injuries and damages that are being complained of and that are now part of the lawsuit. If you open yourself up, if you sue and say you're injured, the other side's going to be able to look in to see if the injuries are true, if you've had them before, and all those sorts of things. Now, One of the most important stages is the deposition process. A deposition is sworn testimony taken before trial. Attorneys will question a witness, even the party, even the plaintiff or the defendant, while a court reporter is there recording everything. Since COVID, most of these are done on Zoom, but they can still be done in person. In car crash cases, the depositions may involve the drivers, witnesses, passengers, treating physicians. In premises liability cases, the depositions may include store employees, property managers, other witnesses, corporate representatives, maintenance personnel. Depositions allow both sides to evaluate credibility, facts, witnesses, and trial risk. In many cases, the defense hires its own experts. In automobile cases, especially, the defense may request what we call a compulsory medical examination, or a CME. The defense doctor may give opinions regarding whether the injuries are related to the incident, whether the condition is permanent, whether future treatment is necessary. Listen, these are doctors who make millions from insurance companies by seeing you for an hour and claiming you are always fine, or it's a minimal injury, or that you've always had this problem and that there's nothing there now. That's how they keep getting work from insurance companies. They haven't built a relationship with you. Often they haven't even reviewed all of your records, and they certainly aren't treating you. They are defense doctors. Now, in the slip and fall or premises liability cases, they may involve engineers, safety experts, or biomechanical experts. Before trial, practically all Florida personal injury cases go to mediation. Judges require it. Mediation is a confidential settlement conference with a neutral third party, the mediator. The mediator does not decide the case. Typically, they're attorneys. Many times they could be former judges. Now, instead, what this mediator does is help both sides evaluate liability risks, medical evidence, jury exposure, and settlement possibilities. Many cases settle here, but some don't. Now, if the case doesn't resolve, it proceeds towards trial. Now, there was a recent rule change in Florida that requires cases be set for trial within 18 months after the lawsuit is filed and tried within that time. At trial, lawyers present witness testimony, medical evidence, experts, exhibits, and legal arguments to the jury. And it's the jury who decides fault, comparative negligence, and damages. And this is true for both automobile and premises liability cases. So, what is the Florida personal injury litigation process? It's not just filing paperwork. It's a long process of medical treatment, investigation, evidence gathering, negotiation, litigation, and sometimes trial. Every case moves differently because every injury and every person and every recovery is different. I'm George Palaidis, a Florida personal injury attorney. The more you understand the process, the better prepared you are to navigate it.